Good morning. This hearing of the Subcommittee on Intellectual Property, Competition, and the Internet will come to order. And our fourth witness is Mr. James Grimmelmann, Professor of Law at New York Law School. Professor Grimmelmann studies technology issues relating to IP, virtual worlds, search engines, online privacy, and other topics. Prior to law school, he worked as a programmer for Microsoft. He received his J.D. from Yale Law School and his A.B. in computer science from Harvard College. Professor Grimmelmann, you get the last word.
I would like to thank Chairman Goodlatte and Ranking Member Watt and all the members of the subcommittee for inviting me to testify today. My name is James Grimmelmann, and I am a professor at New York Law School. Although I'm happy to respond to any of the subcommittee's questions on any of its topics, my testimony today will focus on privacy. The central goal for privacy policy online and on mobile devices must be empowered consumer choice. Good privacy technologies and good privacy laws enable people to choose whether, when, and how open they want to be about their lives. I would like to endorse three essential principles for making real consumer choice a reality. The first is usability. A choice that consumers do not know about, cannot find, or cannot understand is no choice at all. The second is reliability. A consumer who has expressed a choice is entitled to expect that it will be respected. And the third is innovation for privacy. Users benefit from good tools to help them manage their privacy. A good example of these principles in action is social networks. Their value depends on controlled access. Everything from a private email from a mother with advice to her daughter in college to a confidential discussion group for recovering alcoholics requires sharing with some people, but not with others. The proliferation of social networks with different technical models of sharing represents innovation for privacy in action. But that privacy must also be usable and reliable. People have lost jobs, been stalked, and been splashed across the tabloids because privacy settings on social networks were too confusing for them to understand. I'm particularly concerned about what I have called privacy lurches, sudden and unexpected shifts in a social network's information sharing practices. For example, Google mishandled the launch of its Buzz social network in 2010. Without clear warning, Google exposed the names of users' email contacts to the world. This made Google Buzz, in one reporter's words, a danger zone for reporters, psychiatrists, lawyers, and everyone else for whom confidentiality is essential to their job. The Buzz rollout violated the principle of reliability. It changed Gmail's privacy practices in a way that users could not have anticipated and that was capable of causing significant harm to them. A Federal Trade Commission investigation resulted in a settlement designed to prevent similar mistakes from happening again. And I have also suggested that privacy lurches may expose companies to legal liability for distributing an unreasonably dangerous product. Another example of the principles is online behavioral advertising, the use of unique identifiers known as cookies to track users and to customize the ads they see. Some users appreciate receiving relevant advertising. Others find the tracking creepy. Industry participants recognize this difference in opinions and offer users a choice of whether to be tracked. One of the best ways to ensure that these choices are usable and reliable is through innovation for privacy, promoting the development of tools that users can use to manage their tracking preferences and express them clearly to websites and advertisers. The best innovation here has come from web browsers, antivirus software, and plugins that help users block and delete unwanted cookies. And the current consensus process to develop a do not track standard is another encouraging step. All of these innovations can succeed only if they are respected by websites and advertisers. The Federal Trade Commission has taken important action against companies that circumvent users' privacy-protecting technologies, and the FTC and Congress should ensure that websites are not permitted to second-guess users' expressed privacy preferences. Thank you for the opportunity to speak with you today, and I look forward to your questions.
Sure. Thank you, Professor Grimmelmann.
Okay. Next question is, should consumers be able to opt out of the process that gathers that personal information about them? Professor Grimmelmann, do you have an opinion on that?
In the context of first-party collection where the consumer is dealing with a website,
yes,
Mr. Shipman expresses a very clear and correct view.
And you agree with him? Okay. That concludes my questions. The gentleman from Michigan, the ranking member of the full committee, is recognized for his question.
Thank you, Chairman. Let me turn to Professor Grimmelmann for a continuation of this discussion. How do you see this discussion of giving benefit to the doubt to these huge companies that are collecting what we don't even, well, from my point of view, it's everything. We go back to Sears in 1900. Well, guess what they're doing now, if you think that was something?
I would like to say that some huge companies can play an important role in building tools that stop other huge companies from gathering lots of data. So, for example, Apple puts significant restrictions in the iPhone that limit the data that apps can collect, so that the apps can't gather location data without the user's express permission. And Microsoft is bundling, in its most recent version of the Internet Explorer, will be turning on the Do Not Track header by default to tell websites that they should not collect data about users. We can find ways to exploit the competitive process in the industry to have companies recognize privacy as an advantage and help consumers keep personal data from other companies.
But there's some that are disregarding the tracking instructions of their consumers. You know that.
So the advantage of that is that the company that disregards the tracking request has now done something that's explicitly deceiving the consumer and failing to respond to the request rather than just taking advantage of their ignorance, which gives the FTC a surer basis for action.
Thank you, Mr. Chairman.
Thank you, Mr. Conyers. The gentleman from Pennsylvania, Mr. Marino, is recognized for his question.
Thank you, Mr. Chairman. Professor, maybe you can give me a quick answer on this. Can the industry police itself? I have a little problem with the Fox setting rules and regulation for the hen house, but give me a scenario, if you would contrast them, policing itself and needing Professor.
That the companies that you are most going to want federal intervention for are the ones who are not trustee members, who are engaged in shady, gray area marketing that conceal their tracks, click fraud, all kinds of shady deals that are trying to rip consumers off.
Okay, thank you. I yield back. Thank you.
I think Americans have a reasonable expectation of privacy, but how do we define that? One of the things that I think we have to look at is airspace. What is the proper balance of airspace? Anybody care to take a stab at that one?
I can say a little bit about that. One of the encouraging things about the Supreme Court's decision in the United States versus Jones is that the court endorsed two different kinds of rationales for protecting privacy. One of them, based in the majority, is rooted in the historic law of trespass. And there, that might signal a reinvigoration of the idea that the airspace closely above your home is actually yours and not to be invaded. We've long accepted that commercial airlines can fly far overhead, but this might signal an attitude that we should protect your sovereignty over your own space close to the ground. And the second, coming from the concurrences, is the so-called mosaic theory that continuous observation over a long period of time can ultimately build such a complete portrait that it does invade one's expectation of privacy.
And I guess that's one of the challenges, Mr. Chairman, we face, because he's right in the Jones case, which is in large part what our legislation is modeled after, is this idea that there's a toggling between an individual's movements on private property and out in the public space.
I'm wondering how this process is working relative to the recent decision on Internet Explorer to make the default do not track. I understand that and certainly Microsoft has the right to do that. Has that had an impact on the industry-wide effort to reach consensus on do not track or not? Professor, could you answer that question?
So the decision has been discussed within the working group that is building the standard. Some of the participants in that group, including representatives from Google, Yahoo, and Adobe, have taken the position that Internet Explorer should be defined to be non-compliant, such that websites could say, I think you're using Internet Explorer, therefore I'm not going to honor your do not track request. And I think this is simply an attempt to sabotage the standard. It won't work if websites can second guess the user's statement, I don't want to be tracked.
Well, the question, I guess, is, for me, what's the default? What kind of transparency is available to the user? And also, what kind of accountability is there if the user's choice is, in fact, not honored by the person representing the choice? And I guess the question is, who owns this data? Maybe that's something that does need to be established in law, that the individual has an opportunity to enforce their own choices. Do you think that is an approach that would be helpful for Congress to take?
The default right now is that websites collect but offer users an opportunity to opt out. I think users should have the opportunity to choose tools that protect their privacy by saying, do not collect. And if websites disagree with that choice, they can communicate with the user and say, here are the benefits we could offer you if you turned tracking on.
And that's, for example, I use Firefox as I don't know why, but I've always used it. And I've got do not track turned on my Firefox because that's a choice I want to make. But it means that there's some things I can't do on Firefox, which is a decision I've made. Wouldn't it solve our problem in the Internet world if we were just transparent to users and gave them enforceable choices?
Yes.
A breach in security protocol by a company such as eBay that exposes private customer information to the public could result in death or grievous bodily injury to a customer whose private information was divulged wrongfully. The consumer certainly has a right to recover damages for his or her injury or their next of kin for their death. I'm sure you all would not disagree with that. Do you think that it's important that consumers have the right to take their matter to court as well? Professor Grimmelmann, your response, sir, or insight?
I agree with him that where there is physical harm to the individual who's been hurt as a result of the breach, then yes, the courts are available and they've been willing to hear those suits. I'm concerned somewhat that the breaches that do not result in immediate provable harm, but nonetheless reduce the information security for all of us by leaking financial information on many consumers that can lead to acts of identity theft that can't specifically be traced back to that one individual breach, have resulted in harm that's not provable in a court of law, and so therefore there's no redress against it. This is why data breach notification laws and other efforts to shine a light on this and enforce basic information security practices against industry participants are important.
Class action litigation could play a part in deterring willful misconduct that could ensue. Your response to that, Professor Grimmelmann?
This is an area in
Go
which
ahead.
This is an area in which your concern about arbitration waivers is especially important, and this is also an area in which class action litigation has been important for privacy. Facebook has recently settled a lawsuit over its marketing of commercial products using individuals' pictures to say, James just watched Wall-E, don't you want to watch it too? To their friends. And the class action lawsuit resulted in a $10 million settlement.
Thank you.
What I want to know for sure here is, does anyone here believe that the federal government should impose a one-size-fits-all regulatory approach, or that the federal government should prescribe specific privacy policies to specific companies, or in general? Mr.
I
Grimmelmann.
agree that government should not regulate specific privacy policies. It should make sure that consumers have effective notice of what those policies are and have enforcement when those promises are broken.
Thank you very much. That's definitely clarifying information. And with that, I again thank all of our distinguished witnesses, and the hearing is adjourned.